Hi, I'm Greg Dell, joined by attorney Stephen Jessup. And Stephen, we're going to talk about long-term disability insurance lawsuits. And for people who are watching this video, they've basically received some kind of denial letter from their long-term disability insurance company saying you've exhausted all of your remedies, or we're not agreeing to pay you for whatever those reasons are, and now you have the right to file a lawsuit. We've handled these lawsuits against every major disability insurance company. We handle these cases all over the country. There's about 40 disability insurance companies out there. About 12 of them make up about 90% of this $18 to $20 billion industry. They all have their own nuances. They all act in their own manners, which we'll talk about in a little bit. But the place I want to start so that people know what to expect from these lawsuits, what the outcomes can be, how are they handled, what are the time frames. We're going to touch on all of those things in this video. But the first thing for someone who has a denial letter is, what kind of lawsuit do I even have? Where is this lawsuit even going to get filed?
I think the important thing is for people to know there's two really different types of disability policies. There's the individual disability policy that you buy through an agent. That can end up in like federal court, or you could choose to be in state court. They make up a much smaller percentage. I'd say probably 5 to 10% of any call we get is on an individual disability policy. So that's kind of its own separate animal and beast. The vast majority are going to be your employer provided policy. That's going to be something you got from your work, right? And that's going to be governed by federal law, the Employee Retirement Security Act, Retirement Income Security Act, or ERISA. Right. So everyone's always like, what's this ERISA? That's the body of law that's going to govern your rights and then what you're going to be able to do in litigation. So when you do receive that final denial, your next level of recourse is filing a lawsuit in federal court. You don't get the option of filing a lawsuit in state court, and state laws don't apply to your employer provided policy. Only the general body of federal law does.
And I don't want to like geek out on this or get too legal into this, because there's a whole body of law of even if a case is governed by ERISA, if it's exempt from ERISA. But let's just spend a minute to talk about the individual disability claims, and then we're going to spend the bulk of our time talking about the ERISA grouped governed plans. The individual plans are the ones for business professionals, business owners, anyone who happened to go to their agent, an insurance agent, and said, just like I bought life insurance, I want to buy an individual policy of disability insurance. And when you file that lawsuit, the claim that you bring, as you know, is a breach of contract action, which is different than what you bring as a breach of fiduciary duty claim when you have a group claim. But the advantages of having an individual disability policy, or what some people consider to be an advantage, is you can immediately file a lawsuit against your disability insurance company. The biggest difference is you're going to get your right to a jury trial, which means a jury of your peers, whether it's 6 people or 12 people, depending upon who the jurisdiction is going to get to hear your case. You're going to have the opportunity to engage in discovery, which means we're going to get to take depositions of the other people, of the doctors, of anyone who's involved with the case. We're going to have the opportunity to do interrogatories and requests for production through whatever's potential facts that could lead to admissible evidence. When we talk about ERISA, we're going to see that you don't get any of those things. And the biggest thing that you get with an individual disability policy is potentially you have the right to bring a claim for bad faith, extra contractual damages, depending upon what state you're in. Now, all of these things, which we'll compare to the ERISA, and we've had other videos where we've compared the differences between an ERISA policy and an individual policy. The individual policies cost, what would you say, 8 to 10 times the amount of a monthly premium to what a group disability coverage is?
If not more, only because there's no exclusionary language, there's no offset language like you find in the group, so it's exponentially more. And that's why you typically see, like you say, business professionals, doctors, lawyers, those are the people that are purchasing these policies.
So when it comes to these individual disability lawsuits, there's tremendous strategy, and it's not always for someone who's sitting there with a denial that right away we're going to go into filing a lawsuit, because we may want to get additional evidence in that we may not be able to get into after the lawsuit's filed. Whereas when it's ERISA, which we're going to shift into right now, you touched on it, I believe, when you first did your opening remarks, was that record's closed. And let's segue into what that means when you say that record's closed.
Yeah, so when you get a final denial, they say, we're upholding our decision, no further remedies, you can file a civil lawsuit under ERISA. As of that letter, nothing. If you didn't submit all the information in your appeal, and a lot of people contact us when they've gotten that final denial, and were either lured into this sense from the insurance company, you just have to write a letter saying you disagree, or I've heard people say my insurance company told me I can't get a lawyer involved until after the appeal process. So they write a letter saying they disagree, thinking that's going to get their claim reopened. But if that claim, if it's upheld, that denial is upheld, now anything you could have added in that appeal stage, you can't. It's done. And you've got to think of it as like a snippet in time, right? From the start of the claim or when the claim was denied up and through that final denial. And that's the only thing a federal judge is going to look at when making a decision and determination as to who wins the case in court.
And we always give the example because we help people obviously with the appeals, and we tell people how important the appeals are. And we even tell them to say, look, you can do your own appeal. But once they make that final decision, if the next day, God forbid, you're driving to your doctor's office and you get sideswiped in a car wreck and break both of your legs, the evidence of you having both legs broken and clearly cannot do anything at that point in time is not coming in your lawsuit. It is completely inadmissible in all situations. So that's very extreme. Not that way when you have an individual disability policy. So it's super, super important. And again, we have lots of videos on how to do a proper appeal, tips for appeals, and all things like that. And we've handled tens of thousands of appeals and won a lot of appeals because you want to win your appeal and not have to get to a lawsuit. But the lawsuit in the ERISA world, which is what we're going to talk about now, comes down to the strength of the record. So the record, or the administrative record as it's called, is what we get a copy of after they make that final denial. And the disability insurance company is required to provide a copy of that administrative record. A lot of people talk negatively about ERISA lawsuits, but I always like to find the positive in everything. And I think there are many positives towards ERISA disability lawsuits. And you and I will go through some of them, and I know I'll let you share the thoughts about why you think it's a positive that you get this whole record.
Well, you know everything in advance, right? An individual going through the discovery process, you're always learning new things, so you have everything you need in order to be able to formulate your argument. Another positiveness of it is if you're on disability and you go out, it's a very stressful time, personally, emotionally, physically, whatever the case may be. A lot of people, and I liken, dealing with an insurance company being in an abusive relationship where no matter how much you try to prove that you're disabled, they make you seem like you're lying, you're not telling the truth, you can't be believed, and they make lots of threats. So the litigation process itself too, one of the big hallmarks of this is some people think, well, when a judge or a jury hears what I have to say, they're going to understand. You don't get this, right? There's no right to a jury trial in court, right? And this does help to speed the process along, right? It's a quicker, litigation process. But I think one of the bigger things is, with no live testimony in court, or even at the closure of your claim, this idea that nothing new can come in. I tell people, hey, at this point, you don't need to worry about your insurance company like hounding you and your doctors, video surveilling you. Like at that point, it's really the work of the attorney. It's a lot of paperwork, a lot of filing of motions. It's not this huge daunting task where some people think, normally we say, hey, we're going to go to court, we're going to tell our story, all this. But then those same shows will show how miserable that experience can be and stressful. A lot of that is removed. So I think where it takes away certain aspects, it does give us as attorneys in advance all the information we need to know. There's going to be no surprises. Everything's in that record.
Yeah, it's only the super experienced litigators, been doing this for 25 years plus, who understand, look, I love our day in court. I'd love to have a jury, don't get me wrong. And I guess I would say, I don't know, depending upon the facts of the case more often than not, I would like to get in front of a jury. I would love, especially for our clients that we represent, to be able to tell their story, that human emotion, to connect with the jurors, to have the doctors come in and testify what's going on, to crush their witnesses on cross-examination and all of those things, and take information from them and show how ineffective and inappropriate and how little they did to review the claim. We don't get to do that in ERISA, but on the flip side, we've saved 8 to 10 months of what's called discovery and going through requests for productions and interrogatories and everything. And now we know what we have. And guess what? Yes, we're stuck, but if we did a great appeal, that's okay. But they're stuck too with what they had. And most of the time, they've done the bare minimum. So I feel more often than not, if we've done a strong, it always goes back to a strong appeal. We have the upper hand over them in the sense of where the evidence is. But then we get into this, what I think is the horrible thing about ERISA, and not so horrible, but the thing that makes ERISA lawsuits like nothing else out there, not like anything we see on TV where we say we're going to get our day in court, we're going to get our fair trial, we go in and the judge is going to do our thing. And there's this thing called the standard of review, of which is the arbitrary and capricious standard. Talk about what that is as simple as you can so that people understand why in many cases, if there's a discretionary clause in a disability policy, that the claimant is starting not on a level playing field, meaning the insurance company's up here and the claimant has to bring it up here.
Yeah, I think the simplest way to put it, and when I talk to people, right versus reasonable, right? As a plaintiff, you have a two-step process. One, you have to establish that they made the wrong call, that they weren't right in saying you weren't disabled, that you were disabled. After that, then it goes to the judge. If the judge finds, hey, I don't think they made the right decision, the judge is going to do analysis to determine whether or not they acted arbitrary and capricious or they had reasonable grounds to deny the claim. There's a school of thought that if the judge finds the person's disabled, then certainly they'll find that they weren't reasonable, but sometimes it can be a close call. An insurance company sometimes will do a lot of reviews, so a judge could apply this reasonableness standard. I've seen plenty of cases where the judge may not have agreed with the insurance company's final decision, but say, you know what, based on everything you do, I think it's reasonable that you had found this, right? So it really ties the hands of the judge quite a bit on it. So you're not trying to establish not only that you were disabled, but that the insurance company was unreasonable in denying your claim. And that's why going back to the idea of the strength of the appeal, because if you don't have a strong appeal, it's going to make it just that much harder. So with that discretionary authority, like you said, you know, people say, oh, what are my chances in court? I mean, I guess 50-50, you win or lose. I feel it takes it to, 30, 70 in favor of the insurance company because you have a lot more to prove. Another really important thing about those discretionary clauses is a lot of people will say, well, I don't agree with the way that they're interpreting this provision of the policy. I think it means this. That discretionary language, the judge is going to defer to the insurance company's interpretation of its plan, not yours. So that's different than the individual with the breach of contract, where if there's ambiguity and conflict, it's decided in your favor. So this is a very unfair area of the law. And I think one thing that you touched upon, and it really got my head thinking, and I've never really said this, I think, of any of our videos, you say you love to have your ability to speak to a jury. I mean, heck, it'd be nice if your judge would talk to the client, right? Like they do in Social Security hearings. The judge can ask questions and kind of assess credibility on some things. But this is, you have to realize, a very dehumanizing, area of the law. I mean, heck, we know, when this comes down to drafting your motions for a judge to ultimately make a decision, most of the time they don't even want to hear from the attorneys.
Well, and I want to go into that because we didn't touch on, so how does this go down? We talked about how you're not going to have your day in court, but you do have your day in court, but your day in court comes through your lawyer. So you better get a damn good lawyer who's done this thousands of times and knows what they're doing when it comes to writing motions, going up against the insurance companies, having the respect of the insurance companies, having the respect of the judges and the courts all around the country, which clearly we've earned. But the way this goes down is it's basically a trial on what's called a trial on the papers. Is we submit a brief, which is limited to 25 or 30 pages, in which we have to put in all of our arguments. So we got to take what's often a minimum of 2,000 pages of a claim file, the administrative record we talked about, and present our arguments in accordance with the law to say, number one, this is why our client's disabled, and then number two, if we have that arbitrary and capricious standard that we spoke about, this is why they acted unreasonably. It is a monumental challenge to number one, describe all the reasons why the claimant's disabled, and then go through the body of case law to explain why they acted reasonably. And it's not just our opinion about why they acted reasonably, it's supported by why hundreds of other opinions that have been written by other judges, whether it's this court, an appellate court, the U.S. Supreme Court, says that this conduct by the insurance company is unreasonable. They submit their reply brief. Then sometimes we each get another reply, so we've each done two motions. Sometimes they get a surreply, which is a third. Sometimes it happens, and that whole process takes usually that's a back and forth 4 to 6 month process, give or take, to get those things. And then it's in the judge's hands, and then sometimes the judge grants oral argument. But as you said, often the judge doesn't want to hear from us. And so now it's in front of the judge. But who is really the judge that's looking at this?
Well,
in federal court where we are.
Well, you have the name of the judge, but generally it's going to be their clerks that are going to, review everything and assess. And I think an important thing I tell a lot of clients in understanding this process, especially on timing, right? Recently, last year, I filed two set of motions in two different cases. We are now respectively 9 and almost 11 months out from when those were filed, and nothing from the court, right? And the one thing you can't do is tell a federal judge how quickly they should do something. And I think another really important thing to remember in this area of the law is, unlike in state court, you file your lawsuit, there's civil divisions, there's criminal divisions, right? They're separated, they just handle certain cases. Federal judges run the gamut of cases, right. Mass complex civil cases, federal criminal cases. And I think a lot of times on these ERISA cases, they don't give them the attention because, wait, I don't have to worry about discovery. There's going to be no live testimony. I don't even have to see from the attorneys. So I think these cases can sometimes take a back burner compared to the other cases they have to handle. So it then falls on their clerks to do the review, summarize the case law, and you've said it a lot in videos. This area of the law is like the Wild West. Yeah. For every opinion we can find that supports our position, there's usually one that destroys our position elsewhere. So
challenges.
So it's really like, it's always like a maybe and what if. So the clerks are usually the ones that are going to review everything, and then give their opinions and thoughts to the judge. The judge will look that over, and if agreeing with what their findings are, will then issue an opinion generally based on those.
And then I wanted to speak about the clerks, because these clerks they're the top-notch students coming out of law school at all of the law schools across the country, and they're usually given like a 2-year clerkship. Yeah. They call it. It's a very, very prestigious position. It's like one of the top positions you can get out of law school. But you're still dealing with I'm going back in the years of 24, 25. You're dealing with a 24 or 25-year-old who hopefully is healthy as an ox, a very healthy person, doesn't have much work experience. They've basically gone through high school, gone to college, now they're in law school. They've probably had a couple jobs. Most of their work experience has probably been professional type work, and a lot of the clients are not necessarily in the professional services. They have all kinds of different jobs. These clerks don't have children. It's not necessarily the best representative of someone who's had a lot of life experiences. And now they're having to look at things and say, well, why can't this person, do their sedentary job? Why can't they, do they understand this job? What is it really like to have a 40-hour-a-week job and run a family and do everything else there really is to do in life? I mean, for many of these people, it's the first time they haven't lived at home. And now they've got to look at this person and be like, okay, the insurance company says you can do this. The other people say they can't. And now I got to find all these cases that talk about what's reasonable, what's not reasonable. So I think that's one of the reasons why it takes at these clerks and the judges a while. The other thing is that this administrative record, they have to go through it page by page and review all of the information and then comment on what they reviewed. So we've submitted 50 to 60 pages in our brief plus attachments. The other side has submitted 50 to 60 pages plus attachments. They got to read all of that. They got to get the claim file. They got to do their research of the Wild Wild West, because there are thousands and thousands of ERISA cases. And then the judge has to first draft a written opinion. And in this world, Stephen, probably with ERISA cases, there's probably more, other than criminal cases where people are appealing for their liberty. ERISA is probably one of the single highest civil type cases that has appellate type law, because there's just a lot of things out there. And then a lot of our cases come from the next level of review. Now, a case, you can win it or you can lose it. And it's a benefit that there's a lot of case law out there to appeal, because even if you lose, you might still get a recovery. Nowhere near what the company might have offered. But on the flip side, if you win, you may not also be home free, because they can come back with something and they get another bite at the apple of basically like this quasi de novo fresh review by an appellate court. And more often than not, that's taking a minimum of another year. So what's happening this whole time once you file a lawsuit? It's a minimum by the time you get to this final trial. I mean, I'm going to be like an ultra fast scenario. It can never be less than 18 months.
I agree.
Never. I mean, from the time that the person filed for disability, got denied, did their appeals, filed a lawsuit, get to the hearing with the judge, and then the judge makes a decision. I've never seen it less than a year and a half, and probably more often than not, it's 2 years until you get a judge decision. The reality now, that person's sitting with no income. Maybe they have Social Security disability payments. Maybe they had state disability for a year, but otherwise they have no income. And this is where the disability insurance company has the noose on, and they're tightening that noose and tightening that noose down, because how are you paying the bills as the claimant? And that's the hardest part for us, because we want to push these cases, but there's only so much we can do.
That's why I call claim denials leading to litigation strong arm settlements, right? They know that. They put the pressure. It's a war of attrition. They have deep pockets, you don't. So sometimes I think those denials, it's to try to get you there, and there are strategies to try to move these things along. I think it's really important to note too that the overwhelming majority of these cases are going to settle after a lawsuit's filed at some point. Most federal courts, they don't always, so I won't say every time, but we'll say pretty much always, are going to require some level of mediation where the parties get together to try to resolve it. Some judges will do their own settlement conferences, or they'll do, I had one recently with the judge, just myself and opposing counsel. What's going on with this case? Have we talked about numbers to resolve? So there's always this discussion of resolution going on. So I also tell people too that even in the worst case scenario, right? You have a case that's going to be very difficult to win. Say you did your own appeal, you didn't really supply much. I've had those cases then where the denial was even predicated on the person's treating physician agreeing with the insurance company. It's hard to say they're unreasonable if they agreed with your doctor. You file a lawsuit, the marching orders from the insurance company is still going to be try to settle that case. Now, the value is not going to be great, because value in any settlement is always going to be derived on the strength of the plaintiff's case, but there's still always going to be, something out there. That's why I tell people, don't feel too broken down. The only way you won't see anything from this is if you completely walk away. There's always going to be, the ability to try to get some type of resolution in it. But you're right, so many people are just, and they think, well, hey, I've lost everything. I lost my house, I lost my car, I went into all this debt. If I win, do I get any of that back? Unfortunately, no. That's the big thing. If you win, the judge orders the insurance company to pay you the money they owe you. Now there can be some nuances if they didn't do reviews for any occupation and whatnot, but we'll just say they pay you what they owe you, put you back on claim. There's no guarantee of future benefits. There's no guarantee they won't mess with you again. You might be able to get attorney's fees. That's at the discretion of the court. So we're in a situation where an insurance company has the benefit of the doubt in court under the law, and then their worst day in court may just be paying you the money they owe you. So what's the incentive not to be, jerks about denying cases?
Yeah, there's no incentive for them to fast track the case, and they're not going to get punished unless it's the individual disability claim that we spoke about earlier. And then it depends on the state law if that's even allowed. And unfortunately, with what's called tort reform, a lot of states have tried to knock out with these bad faith damages, or made it even harder, to get to that. But the attorney's fees provision does have a little bit of teeth, especially when dealing with a firm like ours, where we're one of the most experienced long-term disability insurance law firms in the country, and fees can be awarded at upwards of $850 to $1,100 an hour for an hourly fee, which is going to basically make it where our attorney fee that could have to be paid by the insurance company is going to way exceed potentially the amount in controversy. So that's an advantage to bringing in a powerhouse law firm like ours to go, because now they're saying, well, I didn't get the law firm that's just a mill or does these every now and then, and they're going to get paid $300 an hour. I got the $800 to $1,100 an hour law firm that if I win, they're going to get paid their fees. So we're going to push as hard as we can, and if it takes the time or whatever it takes to do it, we're going to do it. And insurance company know that you're going to have to pay our bills, and our client's going to get paid and made whole. So, but you jumped into what the remedies are here. And we win, and it comes down to what you consider a win. I would say 99% of the cases that we've ever represented anybody. And because when I think about a win is not just the obvious win to say you go to court and the judge rules in your favor. Because the reality is that doesn't happen all the time, because people at the end of the day get a reasonable offer, which is another type of win. And that's what happens in the vast majority of these cases, that the disability insurance company knows that they have risk. They're in the insurance business. They know they have some liability. If they lose, they're going to have to pay X amount of dollars. But what they're willing to do, if they believe that it's a real case, which we would never bring a case that's not real, is to say, look, we're going to hedge our bet. We're going to make an offer, a settlement offer, a lump sum. You take this money, you walk away, we're done. It may not be as much as you wanted. It's a lot more than we wanted to pay, but this matter is over, it's final, and it goes away. And what happens is the claimants then have to make a choice. I got X amount of money. Do I want to now invest in this case this amount of money to get this much money? If I got $500, I'm just using very super low numbers, and the max I could get is $1,000, is this the best place to put my money, to double my money? Or do I want that level of certainty to take $500 and let me have that, live my life and do whatever it is, screw the insurance company, I got something out of this, I'm going to move on. But if I lose this case, I may get nothing, and I may get stuck paying their attorney's fees, which could be hundreds of thousands of dollars. So that's big risk. Now what we do is we say to the client, whatever you want to do. You come to us and say, do you think I'm going to win? What do you think my chances are? We're in it with the clients because we only handle these cases on what's called a contingency fee basis, which means we don't get paid unless you recover benefits. So we are not the type of law firm that's pushing, you got to settle, you got to settle. We don't care. I mean, we care, but if you want to go the distance and it's reasonable, we're going to go no matter what. We're never going to try to get a quick buck. So we're going to do what's best for you. But if we think you don't have a shot in hell to win your case, we're going to tell you that you're going to lose. And it's okay, there's money on the table, but you are going to lose. So we're very reasonable. We don't get to the point where we're arguing with the client. More often than not, they want to settle, and you and I want to push.
Yeah, I've had that recently in mediation. I thought it was a case that could be pushed, but the client ultimately, like you said, the bird in hand, what the risks are. And then also for his own mental mindset, after years of fighting with them, they're gone forever. It's done, that chapter is closed.
So what I'd love for people to do, I hope they got a sense of what's going on here. And you know I could go for another 2 hours, but I've just found if we go more than 30 minutes on these videos, no one's watching them anyhow. So I encourage, if you're out there, feel free to call Stephen, myself, any of our lawyers. Again, no matter where you live in the country, we're available to represent you. We'll always provide you with a free initial consultation, and we look forward to the opportunity to discuss your long-term disability lawsuit.